Hi, friends. So there's a major new USCIS policy memorandum that could impact thousands of people applying for green cards inside the United States. And the language in this memo is very strong. USCIS is now emphasizing that adjustment of status, meaning applying for a green card from inside the United States, is not something that applicants are automatically entitled to, even if they qualify under the law. Instead, USCIS is calling adjustment of status an extraordinary relief, a matter of administrative grace, and reminding officers that approval is discretionary. So what does this actually mean? Does this mean adjustment of status is ending? Does this mean that marriage-based green cards are being denied? Does this mean that employment-based applicants are in trouble? And how could this impact people who have pending I-485 applications right now? Today, I want to break down the entire memo carefully and explain what USCIS is really saying and who may be affected the most and what applicants should be doing moving forward. Hello, my name is Ebony Anuforo. I am an immigration attorney, and on my channel and on my platforms, I break down immigration law, USCIS policy, updates, executive orders, and practical immigration strategies in plain English so that immigrants and their families understand what is happening and how these changes may affect them. So I want to get into this policy memo. So on May 21st, 2026, USCIS issued policy memorandum PM 602-0199 and titled it Adjustment of Status is a Matter of Discretion and Administrative Grace and an Extraordinary Relief that permits applicants to dispense with the ordinary consular visa process. The title alone tells us the direction that USCIS is trying to go. Now, importantly, and this is critical, this memo does not change the actual immigration statute. Congress did not pass a new law. Adjustment of status still exists. Marriage-based green cards still exist. Employment-based adjustments still exist. VAWA still exists. 245I still exists. And the eligibility categories still remain, okay? What USCIS is doing here is they're reframing how officers should exercise discretion when deciding whether someone deserves approval of adjustment of status. And that distinction is what really matters here, okay? So let me explain this in simple terms. Adjustment of status under INA 245 allows certain people who are already physically present inside the United States to apply for permanent residence, meaning a green card, without having to leave the country, okay? Normally, immigrant visas are processed abroad at a U.S. embassy or consulate, and that is called consular processing. Adjustment of status is essentially an alternative process that allows eligible individuals to complete the process from within the United States instead of having to leave. Historically, if someone was eligible, if they were admissible and they qualified under the law, USCIS officers often approved these applications unless there was some sort of serious issue with the application or the applicant, the beneficiary. But this memo is telling officers, do not treat adjustment of status approvals as automatic, okay? That's what this memo is telling them. So now let's discuss the part of the memo that has many immigration attorneys really concerned. USCIS repeatedly emphasizes that adjustment of status is discretionary, meaning even if an applicant technically qualifies under the statute, USCIS may still deny the case as a matter of discretion. Now, technically speaking, that has always been true under the immigration law. The issue is that USCIS is now placing much heavier emphasis on that discretionary authority. And the memo specifically says that officers should consider immigration violations, failure to maintain status, failure to depart the U.S. when expected, fraud or misrepresentation, conduct that's inconsistent with the visa intent, whether someone bypassed the quote ordinary consular process. They're asking officers to view these as negative discretionary factors. And that language is extremely important because USCIS is now framing the decision to remain in the United States and pursue adjustment of status instead of consular processing as something officers may weigh negatively in some cases. Now, why is this controversial? This is where policy becomes controversial, okay? Because Congress itself created adjustment of status under INA 245, Congress intentionally allowed certain individuals to apply for permanent residence within the United States. So many attorneys are arguing that USCIS is now undermining the very purpose of adjustment of status, right? By treating the use of that legal process itself as a negative, factor. And this could potentially lead to inconsistent adjudications depending on the officer that is reviewing the case. And that is one of the major concerns that immigration practitioners, attorneys, are really discussing right now. Okay, so now I want to talk about who may be affected the most. Now, the memo appears to specifically be concerning for applicants who have prior status violations, long visa overstays, not long visas, but visas overstays, long periods of unlawful presence, fraud or misrepresentation concerns, unauthorized employment issues, applicants who have weak equities, and people that have complicated immigration histories. So it also potentially affects people who entered on a temporary visa, but then later decide that they wanted to pursue permanent residence. Now, again, this does not automatically make someone ineligible, but USCIS officers are now being encouraged to scrutinize those facts more aggressively under this new discretionary analysis. Okay. Now, there's a critical point that I really want to focus on, is that this memo itself recognizes that certain categories are protected and they are treated differently. For example, USCIS specifically acknowledges that dual intent visas categories like the H-1B and the L-1 are consistent with seeking permanent residence, right? And that is important for employment-based applicants, because if you are on an H-1B or an L-1, there's this understanding that you have dual intent and you eventually might want to apply for a green card in the future. The memo also confirms that, some forms of adjustment of status, including certain refugee, asylee, Cuban Adjustment Act, those are also, different. Additionally, protections under VAWA and other humanitarian provisions still remain, important. So this memo does not eliminate humanitarian protections, but it does signal a broader tightening of discretionary review. So what could this actually mean in real life? Here is what I believe we may start seeing going forward. We're going to see more requests for evidence, more scrutiny during interviews, more focus on discretionary factors, more detailed officer notes, and potentially more denials based on discretion rather than statutory ineligibility. In fact, the memo now insists and instructs officers that if they deny a case based on discretion, they should explain the positive and the negative factors that they considered in making their decision. And that is very significant, because now attorneys may need to be proactive in building stronger discretionary arguments into their adjustment of status filings, meaning that it may no longer be enough to simply just prove that someone is eligible, right? Applicants may now need to also demonstrate more positive equities when they are applying for adjustment of status, right? And some examples of positive equities include your long-term residence in the U.S., so USCIS, U.S. citizen family members, community involvement, your tax compliance, employment history, rehabilitation, hardship potentially to family, your good moral character, humanitarian concerns, military service, strong supportive evidence. In other words, USCIS is signaling that officers should balance positive and negative factors more aggressively. So what should applicants do now? Now, if you currently have a pending adjustment of status application, I do not want people to panic. This memo does not mean that everyone will suddenly be denied for an adjustment of status, but I do think applicants and attorneys should take this more seriously moving forward because, people need to make sure that their filings are complete, that their records are accurate, that they are truthful, that the records are consistent, that they understand their immigration history, and that they address any potential discretionary concerns proactively. And honestly, this memo really just reinforces why individualized legal strategy really matters, because every case is not the same, okay? So my personal opinion on this is that this memo is part of a broader shift towards heightening discretionary enforcement and stricter adjudication. Legally speaking, USCIS is relying on authority that has existed for years, but practically speaking, the tone of this memo does matter because policy memos, they shape officer behavior, they shape adjudication culture within the agency, and they influence how cases are reviewed in real life. So while USCIS says this is simply a reminder of existing law, many attorneys expect that this memo will result in tougher adjustment of status adjudications moving forward. Okay, so this is definitely a policy memo that we will need to watch carefully. And as we begin seeing actual case outcomes under this new guidance, we will get a better understanding and a better sense of how aggressively USCIS plans to apply this discretionary framework. If you currently have a pending adjustment of status case, if you are considering filing for a green card, or if you have concerns about your immigration history, it is important to understand how discretionary factors may impact your case. So you want to speak to an experienced immigration attorney to really help you and guide you through that process. Thank you for watching this discussion. Again, my name is Ebony Anuforo. I am an immigration attorney with the Anuforo Law Firm. And if you found this information and this breakdown helpful, make sure that you follow for more immigration policy updates, USCIS news, and practical immigration advice. I want you to remember that every immigration case is different. And information that I share in this video is for general educational purposes only, and it does not constitute legal advice. But if you do have immigration questions about your own case, please consider speaking to an attorney. You can reach out to my office and we can schedule an individualized legal strategy session. Thank you for watching. Talk to you soon.